Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business before this court will draw near and give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. Well, as you can see by looking around, today is a very special day. It's not an ordinary day of term. Today we begin by acknowledging the Honorable Nancy E. Smith. Her remarkable career in the law, including almost 3 decades spent engaging in and excelling at the demanding work of the Appellate Division. Today is the last time Justice Smith will sit to hear cases. Colleagues of Justice Smith have come to be with us today to honor Justice Smith and to mark the end of a truly impressive career as a jurist. Our entire court is here. We also have, I understand, Bill Taylor, the administrative judge, right over there. The administrative judge for the 7th JD is here to honor Judge Smith. Judge Smith, after starting her legal career in private practice and the Monroe County District Attorney's Office, was elected to the Monroe County Court. She was sworn in as a county court judge in January of 1993. Some folks here may not have been born yet. And later, as a Supreme Court Justice in 1997. Less than 2 years later, Justice Smith's appellate career began when she was designated to sit on the 2nd Department. In 2004, in a roster change that would improve the lives of everyone here, Justice Smith moved from the 2nd Department to join the starting lineup of our court. Tomorrow will mark Justice Smith's 27th year on the appellate court. I asked our 4th Department Law and Library Director, Andrew Clark, to do some research. According to Drew, during the last 27 years, Justice Smith has sat on 19,919 cases. The rulings issued on those cases were upheld an impressive 99.37% of the time. I can confidently speak on behalf of the justices that have sat with Justice Smith and tell you that it has been an honor to work with her. Her work ethic is extraordinary. When you receive a report, a note, or a draft memorandum or opinion on a case from Justice Smith's chambers, you know the work is thoroughly researched and the record has been fully investigated. The legal analysis is always strong. I learned early on that if you were going to disagree with Justice Smith's recommendation on a case, I knew I had better sharpen my pencil. In a word, Justice Smith is formidable. At the same time, and importantly, Justice Smith was always open to the views of her colleagues and willing, if persuaded, to reconsider her position on cases and adjust her sails. To my way of thinking, that is the most valuable trait of an appellate jurist, being able to reconsider your initial view of the facts and law and how they come together on a particular case once you hear from your fellow panel members. With Justice Smith, it has never been about ego, but only about reaching the correct decision for the benefit of the public, the bar, and the court. To that end, she has sacrificed her time, working nights, weekends, and holidays, to be fully prepared for her court duties. She has always taken on extra assignments when called upon by the bar associations, law schools, and I have called upon her plenty. The committees, speaking and lecturing engagements, and honors are too many to list here. We here at the Fourth Department are not the only ones to have noticed Justice Smith's legal abilities. The Chief Judge of the Court of Appeals called upon Justice Smith to sit on a case at the Court of Appeals when a recusal on the court resulted in the need for a vouched-in judge. The Chief Judge could have picked from the many appellate division jurists across the state, but instead looked to our court. I can imagine that this was an easy decision based on the fine reputation Justice Smith holds throughout the entire state. Justice Smith, through her work on this court and the Second Department, has not just brought deserved honor on herself, but she's also elevated the reputation of our court across the state. As a colleague, Justice Smith has always been a pleasure to work with. She is, simply put, she's great company. As a court, we spend a lot of time together. The hours we spend working, especially during term, are long. During the work days, we visit regularly to discuss cases, and we also dine together often. Through the years, we share wonderful family moments like graduations, marriages of children, the birth of grandchildren. We also see each other through illness and other less happy times. Justice Smith has always been there for her colleagues and members of this court staff who are here with us today. She's there with assistance and with a kind word. I will end by saying what I will miss most: her sense of humor and that wonderful laugh. All of the justices she had served with throughout the years will tell you. At any time throughout the day, you can hear Justice Smith's laugh echoing down the hallway. It never fails to bring a smile to my face. But now it's time for Justice Smith to hang up her judicial robe and turn the page to her next chapter. Nancy, thank you for your incredible service to our fellow citizens of New York State for these many, many years. Thank you for your valuable leadership as Senior Associate Justice on our court. And most of all, thank you for your friendship and all the kindness that flows from that friendship. I speak for all of us on the court, both justices and staff, when I say you will be greatly missed. We wish you a long, healthy, happy, and well-deserved retirement. Please all join me in congratulating Justice Nancy E. Smith on an extraordinary career and thanking her for the remarkable impact she has had on the common law of our great state. You may, please.
Thank you. Thank you so much, Presiding Justice Whalen. I so appreciate your kind words this morning, but mostly your support for all these years. It's been such an honor and delight to serve on the Appellate Division 4th Department with you at the helm. Your leadership and dedication to the court is truly outstanding and is so appreciated by all of us. Thank you. And to all my past and present colleagues on the bench. And of course, there are many more past than presents because I have been here for basically ever, okay? and you made a point to show how old I am. I feel so lucky and privileged to have sat with such outstanding jurists and wonderful friends. To be surrounded by such exceptional individuals is truly amazing. And it's been such a pleasure to sit with each of you. Thank you. And to the remarkable, and look at you all here, the remarkable and absolutely wonderful court staff. Again, both past and present, mostly past. We have been surrounded and supported by individuals of such high quality who exemplify hard work and dedication, and who also maintain senses of humor and unrelenting friendship and bonds, and it's so amazing. We couldn't do our work without your efforts and consistent assistance. I will miss you so much, and will miss our daily inside jokes, such as, and where do I sit? As an example, which recently was no longer a sarcastic comment, as my position on the bench had changed, so I really didn't know what I was supposed to say. So, thank you. And to my confidential law clerks, starting with Mike Masulo, who was so helpful at the beginning of this journey. Thank you. And then Jim Stevenson. He joined Lori and I and was with us for almost 17 years. He has an amazing legal mind and was such an incredible partner during this adventure. And he's also a faithful and devoted friend. I can never give you enough credit, Jim. I could not have done this without you. Thank you. Hey, and then I was so lucky and privileged to be working with Colleen Farrell for a nanosecond. I wish we had more time working together, but I appreciate and cherish the time that we had together. It was wonderful. Thank you. Where is he? Okay, Joe Soroka. You know that you're next. Thanks for stepping in and being by my side, figuring out these cases in the law during our time together. You are amazing at what you do, and your insights and hard work is so much appreciated by the entire court. We also had a lot of fun along the way. Thank you. And Chris Larrabee stepped up to go through to the end of my career with me. It has been such a pleasure working with you, and you've been incredibly helpful. Thank you. And now, Lori Quill. There are no words to express my gratitude to you. We embarked on this adventure together, and we've been beside each other ever since, for everything. Together we have weathered ups and downs, highs and lows, both professionally and personally. Lori is more than a colleague. She is like a sister to me. Lori's dedication and support extends beyond me. She's always there to assist all of the members of the court, especially those out-of-town judges when they're here during term. And she makes herself available to help out when needed, and everyone on the court appreciates her unending support, especially Justice Bannister. So trust me, the justices on this court will miss her a lot more than they will miss me. Thank you. And to my spouse, Larry Hickey, who is present in court today, without your unending and unwavering, most of the time, support, and love and dedication, my career would not have been possible. Mostly, thanks for putting up with me for all these years. Love you and thank you from the bottom of my heart. And my children who couldn't be here today, Connor Hickey and Maggie Hickey. Lots of sacrifice on their part, especially when they were growing up and I was commuting to Brooklyn while I was sitting on the second department. And then there were all those years of family schedules which were dictated by the court schedule, etc. And the late nights and weekends when I was basically unavailable due to my court responsibilities. I cannot thank you enough for your enduring love and support. You're the best children ever. Thank you. And thanks to my son-in-law, John Lerner, for your patience and unrelenting support of me, for everything you've had to put up with me. It is so appreciated. Thank you. And lastly, to my granddaughters, Hadley and Maddie, who, by the way, are practically perfect in every way. You two are my pride and joy and make me so happy. I can't wait to spend more time with you in my retirement. Love you so much. Thank you. And with that, I think you have my argument.
Okay, and with that, we'll take a few minutes break just to clear out the courtroom and get the argument started shortly thereafter. That was good. Very good. Yes.
All right. Thanks.
So I thought we were going to get an argument in 237, but apparently that's now submitted. So 237, the first one, I did. Well, yeah, I agree. I couldn't agree more.
Without a council, I do.
Yeah. I thought there were arguments, but it's not. It's now listed as submitted.
When did that change? Today?
Must have.
Yeah.
Yes, well, I was waiting to see what they could possibly say.
Right? Exactly. Okay. Okay, we'll get underway. The first case on for argument today is case 239, People versus Mantzords. And I apologize for the pronunciation
Or
mispronunciation. Thank you.
Morning.
Mr. Reed, can you hear us?
Good morning. Yeah, I as usual, I struggle getting the caption unmuted. So initially, I'd like to.
Counsel, if I could, just out of more apologies to your client, could you pronounce your client's last name for us, please?
Manzoros.
Thank you very much. Appreciate it. Please proceed.
Thank you. Initially, I was listening to and watching the proceedings prior to being called, and once upon a time, I think the last time I appeared in front of Justice Smith was back in 2009, People versus Carl Erb out of Ontario County. And that wasn't my first time appearing before Justice Smith, but that was memorable. And just my comment is simply that it's been a distinct pleasure and honor to argue before Justice Smith when she's on the panel. And I believe in fact, I'm positive on People versus Carl Erb, she was presiding on that day's argument. So congratulations. And I look forward to my time to retire.
We all do. We all hope for a retirement at some point, right? Counsel, thank you for your kind remarks. Please proceed.
Yes, thank you. Thank you. So the basic premise of the brief, which I know was not opposed by a plaintiff respondent, is that there's underlying duplicity in the proofs at trial, which are demonstrated in the motion for the motion in limine for Molyneux evidence. And I submitted that the distinct defect in that application, as illustrated in my brief, is that there is no specified actual criminal act separate from the other criminal acts that are recited in the Molyneux application. And also in the proof, the trial proof, there is no specified criminal act distinctive from the acts that would be considered Molyneux. So the underlying indictment is jurisdictionally defective based upon the duplicity. And I also submitted that count one has a defect on its face where the period of time includes the ostensible victim's birthday, the 13th birthday, being within the time frame of the indictment on count one. And that that testimony was provided consistent with what was alleged after his 13th birthday. So you have an issue there as well with regard to sufficiency on the proofs.
Counsel, there was a jury charge on this, right? With respect to the Molyneux, or am I misremember the record?
I think. Yes, the record, I noted that the judge did not give a Molyneux instruction at the conclusion of the case. And I do note in the brief that at the time the judge did give a Molyneux instruction, there was no temporal context in which to differentiate between what was the alleged conduct and what was
But would that have been the
Molyneux conduct.
time, in terms of addressing that, would that have been the time for defense counsel to step up and address that problematic issue? The distinction between the Molyneux uncharged crimes and the charged crimes in the indictment? And was that done here?
Well, actually, I think at the inception, there was opposition to the Molyneux application from the beginning of the motion in limine. It was opposed and was opposed on duplicity grounds. And also at the argument at the beginning of trial, counsel opposed then. So I believe that the opposition is preserved.
Okay. Anything further?
No, I think that sums up the basic argument. And I do note that the district attorney did not file a response to my argument, so I could not follow up.
Very
with any
good.
reply.
Thank you, counsel.
Thank you. Thank you.
Case 240, People versus Alexander. Counsel, proceed.
Good morning, Your Honors. Alexander Prieto on behalf of the defendant and appellant Devontae Alexander. This morning, I plan to focus on the for-cause challenge issue raised in my brief, but at the end, I will address the foundation issue and then try to address the other issues sort of collectively in the interest of time. Turning to that for-cause challenge, the challenge juror here said that he thought Mr. Alexander committed a crime. He indicated that Mr. Alexander must have done something because the grand jury indicted him.
Counsel, with respect to that, there's a point in time, it strikes me in reading the transcript of that argument may have been a very strong argument because of how conclusively the juror number 9, prospective juror number 9, responded to the question. But isn't that kind of a common thing to have happen during jury selection, to have people who are coming in off the street and first being questioned about this? And isn't that the point of voir dire by the counsel, is to kind of educate the jurors about their new role and their responsibility together with what the court ultimately will charge them? And didn't that correction take place here? It seems to me that the first comments by the prospective juror were troubling. But then upon examination by counsel during voir dire, did the juror kind of come around to the understanding of the role and the responsibilities?
Not far enough. There are really 2 points to the voir dire. One, as Your Honor said, is to educate the jurors on what the standards are that they're going to have to apply. But then it's really to find out, can the jurors follow those standards? Do they have some beliefs, some predisposition that for whatever reason they bring to the case that's going to prevent them from following those standards? And I think that's what didn't happen here. The juror, he never, the things that he said should have been setting off alarm bells. I think we can all agree. And at that point, a judge tasked with making sure there's an impartial jury needed to make sure the right questions were asked on the record. The juror with that predisposition can serve, but he's got to give an unequivocal, the words unequivocal assurance of impartiality.
But in your, I apologize.
Go ahead.
I'll defer.
I'll defer.
In your brief, you focus on Warrington and Johnson, and you talk about not just an unequivocal assurance, but also to refer back to that particular opinion. Because the juror went on to say a number of things that were positive, especially as it went through. And you've indicated in your brief, say, well, it's true, but you have to go back to the original comment, and you rely on those cases. Am I right about that?
Yes, that is my essential point.
Okay. So in going through it, I appreciate that the defense attorney did take a interesting and perhaps a clever strategy in terms of almost inviting the jurors to express the biases, try to get those out as comfortably as possible, giving them a little bit of a sense of comfort here. And this particular juror, number 9, wasn't the only one who said, yeah, I think that just because he's here, he must have done something, that kind of attitude. The question I have is that when the defense attorney changed the question slightly and said, well, not about, what happened when we walked in the room, but can you presume he did nothing? And this is page 164 of the transcript. Can you presume he did nothing? He was talking to juror number 10 for a couple of questions, and then he turns back to juror number 9. And that's when juror number 9 said, well, I think your wording's now different. And it was. It's not about what you came in the room with. It's now, can you presume he did nothing? And the question was, just so I'm clear, as you sit here right now in your mind, then the juror said, can't assume until proven guilty. It's like he finally got it. Like it dawned on him. It's like, oh, I get it now. I understand. And then the defense attorney says, all right, et cetera, and then continues on and actually used that juror as an example to the others that he sort of understood. Isn't that question, can't assume until proven guilty, isn't that the linkage that the court in Warrington and Johnson were looking at?
That's as close as we get, but it's not enough because it doesn't really force him to confront what he's expressed before. He's not really confronting this idea that, well, Mr. Alexander must have done something. The grand jury indictment is some evidence what happened. So we don't really know on this record unequivocally when push comes to shove, and he's back there in that jury room, what's going to carry the day? Is it going to be this recognition that, yes, as a juror, I'm supposed to presume the defendant innocent, or is it going to be this sort of feeling that he brought to the table that he must have done something? Do we know that when he's back in that room, he's not going to be thinking, well, maybe the grand juror saw some evidence that we didn't see, or, geez, that's a lot of people. A lot of my fellow jurors want to convict, and so did these grand jurors. We don't know. There's just not enough. Because the Court of Appeals has stressed that need in those cases for the confrontation with the exact belief that's posing the issue for the prospective juror to serve. And it sounds like maybe like I'm making a very exacting analysis here, and I am, but that's because it's a very high standard. The standard is unequivocal. We don't get, in my view, to unequivocal on this record. And that standard is high for a reason, because the right to an impartial jury is a cornerstone of our system. Without it, everything falls apart. And the Court of Appeals has said time and time again that a trial judge should err on the side of excusing a jury rather than testing the bounds of discretion by allowing a juror of dubious impartiality to serve. And I think that's what the trial court did here. It tested the bounds of discretion, and the impartiality of this juror, when you look at everything in context, is still dubious. And so he crossed the line on those boundaries of discretion. For that reason, for-cause challenge should have been granted, and the judgment has to be reversed since peremptories were exhausted.
We'll take a look at that, counsel. You have another argument you want to make?
Yeah, so I want to talk about the foundation issue for the videos that were supposed to basically illustrate, the GPS data for the juries. The actual data was on that. It's, I believe, Exhibit 31A. It's this giant spreadsheet. It's basically illegible. That doesn't prove anything. So I guess the people need to have some kind of way of representing what that data really means. And that's what these videos were supposed to do. But the foundation wasn't there. And it wasn't there, in my view, because the prosecutor basically tried to take a shortcut. They said he put a bunch of things that were all really separate exhibits with separate foundations on the same DVD or disc and tried to admit the whole thing, lay a foundation for all of that at once. And because he did that, there was a piece missing. And here I want to go back and really look at the transcript of what the witness actually said and what was actually before the judge at the time that he made that foundation ruling. He said, what's on the disc? Is that stuff from your company's servers? And the witness says, yes. He says, it's a certification letter, an enrollee track subpoena report, that's the 31A, and multiple video files that were created. So all we know at this point, video files were created somehow by somebody. Were they created with a video camera, with some sort of computer? We don't know. And we never get that. He goes on to talk a lot about the subpoena report, which isn't an issue. And then he says that these are identical to what's on the servers. It's identical, but what is it? And this is the last thing he says before the trial court rules that there's a foundation. I did review the files based on the data that was reported by the device for the time frame that was requested. I consider it to be an accurate depiction of the device's location. But there's a missing step. What's between videos that were created and these videos are an accurate depiction? It's not there. Now, my view when I read this record is that the trial judge essentially, he kind of made an assumption or really a guess. Well, I see where he's going. This kind of looks like the kind of evidence that I've seen in other cases dealing with this GPS data. But guesses and shortcuts aren't good enough. This was a murder trial with a potential life sentence. Maybe the foundation could have been laid, but it wasn't laid at the time the exhibit was admitted, so the exhibit should have been excluded. And just briefly, there were a lot of other trial errors. I don't have time this morning to go on all of them. I think I've made the case for why those were errors in my brief. The misstatements, statements outside the record during closing, the non-eyewitness identification testimony, the missing witness instruction. And the point I want to emphasize is that all of those go to the issue of identity, which was only the real issue in this case. And it wasn't an overwhelming case of identity. Yes, we had that GPS evidence, but that wasn't enough in itself, even if it does get in. The people recognize that because they were putting in all sorts of other evidence to say, hey, jurors, you can trust this GPS. You can trust it's accurate because here's some photos of this guy that this witness says is the defendant at this other place where the GPS said he was. And
That should begin to wrap up.
yes, I will. Thank you. The GPS, other than that, it was basically the baseball cap. It was the GPS plus the baseball cap and the Dodgers cap. All the evidence showed, they tried to say it was something else, but all it really showed was that Mr. Alexander owned a Dodgers cap, and so did the person whose face you can't see on the video of the incident. It didn't show that it was the same model of Dodgers cap or identical. The prosecutor tried to make that, but it didn't show. So when you look at that in a case with no eyewitness testimony, no surveillance footage suitable for identification, no motive put forward, and it's all about identity, any one of those errors could have swayed the verdict, but I think if you look at them collectively, there's a strong chance that they did.
Thank you,
Thank
counsel.
you.
Good morning, Your Honors. Aaron Schwaller for the people. With respect to the juror issue, the for-cause challenge, what we have here is essentially three portions or three components that happen. We have jurors saying everything right, jurors saying things that arguably, or at least argued on appeal, were eyebrow-raising, and then jurors saying things rehabilitating him. In the totality, which is how we measure these things, this is a qualified juror. We don't have the evidence that this juror would not be able to render a fair verdict. We don't have that level of bias based on his statements. If Your Honors don't have any questions on that, I can move on. With respect to the foundation, I would submit that Mr. Marino, who worked for 15 years with Securus, stated that, and he tested in granular detail as to how this data, this GPS data that they give to agencies like parole, how it's tracked, how it's stored, how it is essentially connected to the particular parolee. And he's the one who extracted that data, that showed him essentially at the scene of the crime. So the only issue raised on appeal, essentially, in my view, is that the individual who made the disc was his boss at Securus. I believe the people met their burden to demonstrate that what was purported to be true was true, that this was not altered, that this was his GPS data, in fact. Very briefly, with respect to the parole officer, I think this is an instance where she had met with him in the last month. They had a discussion. She put a GPS tracker on him. She was able to say, yeah, that is him. Whereas the jury sitting 10, 20 feet away and say, that's him. But then when the parole officer says that's him in a still frame, that is a coherent way of presenting the people's case. And With respect to the missing witness charge, this is an individual who said, I'm not going to talk to the police. I'm not going to talk to the prosecutor. I didn't see it. I believe that makes him per se unavailable, or I think that's certainly a reasonable choice for the court to make, or determination for the court to arrive at. With respect to prosecutorial misconduct, we had 3 instances argued on summation. 2 were unpreserved. With respect to the instance that was preserved, I believe it's a fair comment on the evidence, or fairly in response to what defense counsel stated. And just very briefly on the evidence overall, with this hat, it's a very distinctive hat. I mean, it's a Dodgers hat, but it's not a Bills hat. This is a Rochester. Not everybody's running around in the Dodgers hat, and it has like particular reflective things on the brim. It says 1958 to 1971. I don't even know what that means, but it is distinctive. They found it in his house the next day when they effectuated the search warrant. He ran, evincing his evidence of guilt. He said certain things during his interview, evincing his evidence of guilt, and on all of those factors, I would simply encourage this court to affirm.
Thank you, counsel.
Congratulations, Justice.
Case 241, People versus Turner. Proceed, counsel.
Morning. May it please the court. Nicholas Stefanzo for Robert Turner. Acquiring an appeal waiver in this case created a significant appearance of impropriety. That appearance of impropriety violates due process and invalidates the waiver. The issue is whether the average judge, under the circumstances, would likely be neutral, or whether they would face an unconstitutional potential for bias. And court initiated, we actually have 2 arguments here. My first argument is that all court initiated appeal waivers meet that burden, or meet that standard, presumptively, for creating appearances of impropriety. And that would be the Sutton case, second department. And the second argument is that this particular court initiated appeal waiver meets that standard under the particular facts of this case.
Are those one and the same?
Those 2 arguments.
Your point that the fact that an appeal waiver may have an appearance of impropriety, it doesn't necessarily mean, or are you saying that it does mean that it's also a violation of due process? Are those two separate issues, or are they one and the same?
I'm sorry, could you clarify?
Your point that a court initiated appeal waiver is invalid. And you said it's invalid because it creates an appearance of impropriety. Not impropriety, but an appearance of impropriety. Does the appearance of impropriety also implicate due process rights?
Yes. I'm not saying that there was actual misconduct or impropriety here. Just that if there's an appearance of impropriety, if it can rise to the level of a due process violation.
But is your position that every time the court initiates a waiver, there's an appearance of impropriety and therefore it's invalid?
I would agree with the Sutton case that all court-initiated appeal waivers presumptively create that appearance of impropriety, with the Sutton caveat that, a court, they sort of carved out a situation that they described that where an appeal waiver would be appropriate.
Well, let's not talk about Sutton for just one moment. Let's talk about the facts here. As I understand it, the court issues its suppression decision right around January 17th and denies suppression. About 2 weeks later, the defendant's in front of that court, and there's some discussion about maybe a plea. And at that point, the defense counsel says on the record, "We understand, Judge, you won't accept the plea unless we also waive our right to appeal."
Yes, even more specific than that.
2 weeks after the court denies suppression, the defendant puts on the record that the court is insisting that a waiver be in place in order to accept the plea.
Not only just an appeal waiver, but specifically the court was not willing to go forward with a plea that would allow for the review of suppression, specifically, not just the general appeal waiver that would also. So theoretically, he might have been willing to waive all of his rights to appeal except for suppression, right? But the court was saying, what I read from defense counsel's comments there was that the court was unwilling to do that. The court did not want suppression to be reviewed on appeal, and that looks bad. And that's part of why the facts of this particular case also create an appearance of impropriety beyond just the presumption of all appeal waiver or all court-initiated appeal waivers.
And in this case, we had the defense counsel was at a bench conference when the judge told counsel that the court would be requiring the appeal waiver. And there had been a communication that there was an interest in appealing the suppression ruling. Counsel stepped back, because of course the bench conference is not recorded, and articulated what had happened. Do I have this right? At the bench conference, and there was no objection by the court as to what defense counsel said, and there was no objection by the prosecution as to what defense counsel said in reiterating what transpired at the bench conference.
That's my recollection.
So we can rely upon, and we should rely upon, what counsel said happened at the bench conference.
Yes, that's also corroborated by the handwritten note on the written appeal waiver, where it signifies that the court was requiring the appeal waiver in the first place.
Does it matter in this particular case that there was no agreement reached at that point? At least that's my understanding of the record, but that rather the agreement on the plea and the sentencing all took place later, and it was under different the plea was different. And at that point, the district attorney's office stepped up and said, we are going to require an appeal waiver based upon the fact that this is now a different plea, and the court is saying that they're going to do a minimum sentence. Does that change the circumstances?
Not at all, because the court could have refused to go along with that. They could have allowed that plea arrangement to go forward without any appeal waiver at all over the prosecution's objection, because this was a plea to the full indictment. So really, the prosecution was just expressing their preference.
Right. I think I hear your argument that it doesn't matter if the defendant got some consideration for giving up his right to appeal. It doesn't matter because he did get a light sentence here, because it was initiated by the court in the first instance. That's what you want us to look at. That's what you want us to decide.
Yes, in this particular case, it all revolves around this suppression decision,
Right.
Which has some significant issues.
We're going to get there.
Okay.
But now we have a situation where the court says, essentially, if you plead guilty to the indictment, I'll give you a light sentence, but you've got to give up your right to appeal. That's what we have in this case, right?
Yes. That's the situation. Yes. So this is distinct from like what you might say would be a regular Sutton application, right? To a case that doesn't have any obvious underlying issues to it, but an appeal waiver is required nonetheless. It's sort of like a pro forma. We always require an appeal waiver, so you require it too. This case has something, something wrong with it that would
We got
an average judge.
shaky suppression ruling here.
Yes,
Right, so-
an average judge would face an unconstitutional potential for bias, is
Right,
what I
right.
would say. If we can move on to the suppression, unless there's more questions.
Please do.
Oh, sure. That's because the gun should have been suppressed for two reasons. And the first is that Mr. Turner never consented to a pat down.
There's some testimony that he said yes when they asked him.
There's testimony that he said yes, but we have the body worn camera footage that contradicts that testimony. When I see it and listen to it carefully, I hear Mr. Turner say, "For what?" That's clear to me. Was not clear to the judge, but what is clear is that he never said yes. Whatever he said, he did not say yes. I would invite the court to listen to for themselves, but it certainly was not a consent. But the second reason is that there was no reasonable suspicion at the time that Officer Hines arrived at the residences and observed Mr. Turner on the neighboring porch, standing silent.
And the people don't even make that argument on appeal. as I read their brief. They're not even, that's been abandoned. Am I right?
I think so, Your Honor. I believe that they are focused on the consent.
The consent.
But this is where the court's decision narrows the analysis as to consent and reasonable suspicion when Officer Hines arrives at the residences. But it's been law for a long time that an anonymous tip of a man with a gun at a location does not give you reasonable suspicion. And this wasn't even that. This was an anonymous tip of a man maybe with a gun at a different location, which is why there's no reasonable suspicion at that point. Unless there are any further questions, I'll rest on my.
Thank you, counsel.
Good morning. May it please the court, April Orlowski for the people. We do not believe that a court-initiated appellate waiver presumptively violates due process. The way this appellate waiver appears to us is that it is a court initiating the appellate waiver in exchange for a lower sentence.
What was the point of asking for a waiver in exchange? The court could have, the defendant pled guilty to the indictment, right?
Yes, that's
so the
true.
people are out of this.
That's true.
And so the court has discretion in sentencing. The court can sentence this defendant as it deems appropriate. Why did it need to make a commitment at the outset of the case and get that defendant to waive his right to appeal?
The defendant has no reason to plead to the entire indictment, but for some sort of appropriate negotiation. The defendant can argue more with the prosecution for a plea, but this gives the defendant some basis that he knows he's only going to get the minimum sentence by pleading to the full indictment.
He should be negotiating. So you're saying it's appropriate for the court, for the defendant here to negotiate with the court over the sentence?
It's not a negotiation. It's an offer from the court, and the court's, for lack of a better term, parameter is sentencing. The prosecution is in charge of pleading. The court is in charge of sentencing. So the court offering defendant pleads to the indictment and I can offer a lower sentencing is not inappropriate or violative of due process whatsoever.
You can understand that it maybe have an appearance though.
I can understand that argument, and to dispense with that, the court asked each of the attorneys if there was anything to their knowledge that was unfair about the appeal waiver, or if it was being required to cover up an error or misconduct in this case, that both of the attorneys, the defense counsel and the prosecutor, said no. So there was no statement on the record when that question was asked, either by the defense counsel or the prosecution, that, you know, Your Honor, we're a little concerned about the suppression hearing ruling. We're not totally feel good about that decision. We feel the appeal waiver might be in use to cover that up. That didn't happen. Both attorneys said no.
Also, Presiding Justice Shankman in the Sutton case points out that the appearance, not suggesting for a minute in this case that the judge sought the appeal waiver to cover up a bad ruling. I'm sure the judge felt the ruling was appropriate, and I'm not suggesting for a minute that there was anything about that, there was cover up or anything like that. But I think in Sutton, Presiding Judge Shankman says, and I think appropriately so, and I'd like your thoughts on this, that it's not whether or not the judge is attempting to, forestall an appeal from a ruling that they may be concerned about. It's the appearance. It's the appearance that the judge, it may look like the judge is doing that. And that's a concern for our court system, to have those kind of appearances. You see that, right?
I agree with you, Your Honor. And first, I'd like to point out that this department does not follow the Sutton decision. There have been two recent cases that this department has not followed Sutton. And one of those cases is being heard by the Court of Appeals, but we don't have an oral argument scheduled yet. But with respect to the appearance issue, the Sutton court noted that if the lower court makes a demand for an appeal waiver, it should articulate its reason on the record to dispel any concern that the court's demand is motivated solely as a means of avoiding appellate review of its decision. And here, the reason for the appellate waiver was put on the record. It said that if the court's inclined to sentence defendant to the minimum, indeed that waiver of his right to appeal is given for the court's favorable sentencing of him. So it is put on the record what the reason is. So I understand.
But the court, if the court articulates the willingness to go with a minimum sentence to the defendant under the circumstances, in other words, without concern for rulings that the court has engaged in and has issued, I should say, right?
Mm-hmm.
The sentence is the sentence, and the court, by the way, isn't actually bound by that because, you know, if the pre-sentence report comes back and changes the facts that the judge wasn't made aware of, the judge can withdraw that and allow the defendant to withdraw. So it's a conditional promise on the sentence, but it still doesn't take away from the concern that Judge Presiding Justice Shankman points out. He's saying an articulation for a reason why the appeal waiver has to. Now, if your argument is, well, that appeal waiver is only being offered, or the appeal waiver is required, which is what the court required here. I don't think there's any dispute about that.
Absolutely.
Right? The appeal waiver is being required in exchange for a conditional promise of a minimum sentence. I don't know that that's a reason for an appeal waiver.
Well, Your Honor,
to be demanded.
I think that's one of the issues that the Court of Appeals is going to get into when it hears Gaines.
We may beat them to it.
Hopefully, I will say this, that I don't believe there's any due process violation by the court doing this, because it is within the court's discretion to decide sentencing matters. Now, whether the court may offer the appeal waiver in exchange for a lower sentence and decide not to do so because the defendant doesn't comply with one of the conditions, such as not being arrested or, you know, not showing up at sentencing, whatever those conditions may be, or the defendant's PSI is replete with levels of crime that the judge wasn't expecting. I still think that most judges anticipate not doing that and strive not to do that. So even if the sentencing report is worse than the judge anticipated, what will mostly prevent the judge from not following through with that determination is an act by the defendant, such as not showing up for sentencing or receiving another arrest.
Is your argument with respect to suppression limited to just the consent now?
Well, yes, because as it says in my brief, you know, the suppression hearing is covered by all aspects of the waiver of appeal, so that wouldn't be going forward if the waiver of appeal is found valid. But we don't believe the suppression hearing should be granted because the officers approached and engaged in a common law inquiry, which was appropriate given the circumstances.
Engaged in a what? I didn't hear that.
They approached and engaged in a level 2 de boer common law inquiry because they received the 911 received an anonymous call about an argument and a man with a gun. The officer arrived at the scene between 30 seconds and a minute later. He sees the defendant on the porch of the house next door. The defendant's not a mile or even a half mile away. He's on the porch of the house next door where the 911 call comes in about. The officer, it's an unlit porch, but the officer can see the gentleman has his hands in his pocket and he's wearing bulky clothing that the officer.
We're familiar with the facts,
Okay.
but you get to the point where the officer approaches
He does.
the defendant.
Yes.
And asks for, it says, do you mind if I, words to the effect, do you mind if we pat you down?
Yes, that's unintelligible on the body worn camera.
Right.
But the officer testifies that the defendant says yes. And that the pat down begins, and then as the pat down is
And the trial
going.
court credited the officer's
Yes.
testimony.
Yes,
Right?
the trial court believes the officer was testifying truthfully. As the pat down is ongoing, the defendant then says, basically, I don't got anything on me, but that's not before, that's while the pat down is taking place.
Let's break this down for a moment, if I can.
Of course.
When the judge denied suppression, the judge did it on two grounds. One, that the defendant had consented to the search, and two, that there was a reasonable suspicion for a level 3 pat down frisk. You don't make that argument. There's no level 3 here. You agree. The judge was wrong on that part of it.
We didn't, we believe it was.
So we're left with the level 2
Yes.
inquiry with consent.
Yes.
And the burden of establishing consent is on the people, correct?
Yes.
And the officer says, I asked him the question and his answer was really unequivocally yes.
Yes.
If we were to watch the body cam footage and we don't hear a yes, or we hear a muffled, or we hear a what for, and we've got a conflict.
We have the officer's testimony saying the defendant told me yes.
But even though we've heard the body cam footage and we didn't hear a yes, we've got an issue here on whether or not it's an unequivocal consent to a search, correct?
Yes, you do. If you don't believe the officer, you do.
And part of your argument is that the court who saw the officer testify credited the officer.
Yes.
Right. So you say you carry your burden through the testimony of the officer, in spite of the fact that I think the body cam footage does not confirm what the officer says happened on the porch.
I mean, I listened to that body cam a million times, and it seemed to me that I could not hear what he was saying. I honestly could not understand what he was saying.
It doesn't confirm.
Yes.
The yes.
It does not. It's unintelligible.
Okay. Anything further, Counselor?
No, Your Honor. Thank you.
Thank you. Case 242, People versus Hughes. Mr. Keene, can you hear us?
I can, Your Honor.
Very good. Proceed.
Good morning. May it please the court. Brad Keem, and I represent Samantha, the appellant. Before I start, if I may, Justice Smith, back in the snowy winter of 2008, I rushed out of my apartment in Syracuse with my winter coat on, but not my suit jacket. I was completely mortified when I approached the podium for what was my third or fourth argument ever. And though Justice Green suggested not hearing from me at all, your kindness won that day, and I was able to argue. And I just wanted to thank you for that moment of kindness to a young attorney, and the many, many times that though you said you had my argument, you let me get it out. So thank you, Justice Smith.
Proceed, counsel. Thank you for your kind remarks.
We assert that Samantha should have been granted resentencing pursuant to DVSJA. Specifically, when we look at the DVSJA elements, her boyfriend forced her to abort a child and then disparaged her for having that abortion. It caused her to feel depressed and use drugs. We assert then that she was the victim of domestic violence at the time of the offense. It was also a contributing factor to the commission of the offense. The boyfriend controlled her, and she would do anything to appease him. She has a history of this kind of abuse and control. And then when we look at the third part, the character and circumstances of Samantha, this is a person who, while incarcerated, got her associate's degree, took a class in the Columbia Business School. I understand that she's on parole now, but we would assert that it's still a unnecessary use of judicial resources for her even to be on parole at this time. So we would ask that the court provide her relief under DVSJA.
Thank you, counsel.
Good morning. Marty McCarthy for the people. Justice Smith, thank you for your decades of legal service, which is weird because you're only 35 years old. Your Honors, the court properly denied sentencing here. For one, this defendant wasn't eligible for post-conviction relief because she was effectively sentenced after the effective date of DVSJA. She needed to proceed under 6012 and she didn't. That being said, the assertions counsel are making on appeal, there's a requirement for two pieces of evidence, and there were not two pieces of evidence for the boyfriend's alleged abuse of this particular defendant. And absent that, there's a failure of proof to even get to the point of having a hearing. They attempted to bootstrap the boyfriend's abuse with they did have a piece of evidence with respect to the mother's relationship with the defendant. That being said, the defendant and the mother hadn't lived together for a number of years, so that abuse was not temporally related to the crime. There was no temporal nexus between those two things. And because there was no piece of evidence with respect to the boyfriend's alleged abuse, I mean, the PSI makes no mention of it at all. It's not mentioned anywhere in a court record or anywhere else. There was a failure of proof on that. There are no other questions?
No other questions, counsel?
You have my argument.
Thank you. Case 243, People versus GM Bellucca. Thank you. I'm struggling today for some reason. I apologize.
Morning, Your Honors. If I could just start with a quick anecdote. Justice Smith, I've been coming up here for 25 years. You probably heard dozens of my cases on both sides of the aisle. And every time I came up here, I'm like, what can I say to make her laugh? And I can say that I've accomplished that more than once. Now, whether or not that was because I was funny or inept, that's a whole other story. But thank you for allowing me to come up here and see your smile and laugh. May it please the court, Sean Hennessy for Mr. Gianbaluca. I have two arguments, sufficiency and weight, and whether or not his confession was coerced, or if he understood his Miranda rights. Regarding the first argument, Your Honors, I would contend that the people's evidence showing the causal link between Mr. Rados's, the victim's injury, and his death is incomplete. When you look at the evidence and you look at what the testimony was, you have testimony from the victim's daughter that he was placed on life support and that he was taken off life support a day or two later. Combine that with what the medical examiner said, that he died of blunt force trauma. Now, just to go back a little bit, his daughter said that he died because he was removed from the respirator. But what's missing in all that is the evidence that any injuries caused the damage to his brain, any medical testimony linking the assault to being put on a ventilator, to being taken off the ventilator. It's not enough for the causal chain here. I mean, probably he did it.
Let me ask you this. What was needed to be enough? What is missing?
Testimony from any kind of hospital staff whatsoever, a doctor, a nurse, EMT, anything that would suggest that, yes, he received these injuries from blunt force trauma. We can then infer that he got that blunt force trauma from the robbery, but we're missing all that.
No,
Go ahead, Karen.
there was testimony that the defendant hit him with a piece of lumber.
There was definitely testimony for that, but there was no testimony establishing that getting hit from that piece of lumber actually caused him to be put on a respirator. I understand that he was hit, and we can guess that he did. Yes, we can infer that, but inference isn't enough here.
Fractured skull, that was confirmed.
That was confirmed, yes.
From the hit, okay?
Well, but not from the hit, Your Honor. No one actually
Okay.
linked it up to that.
All right, so when you have the piece of wood with the victim's blood and hair on it, how much more of a connection do you need?
You need a connection to say that, yes, he received brain damage from a medical expert, from somebody who attended him, who worked on him for the 2 days that he remained alive.
So follow with me, okay, so
Sure.
he was bleeding, the victim, bleeding in the parking lot after being hit in the head with a baluster, okay? And there's blood in the parking lot, there's blood going to his car. Somehow he was able to get in his car and drive home, where he then bled out and died.
Yes.
Okay, and so I guess, Justice Whalen asked you, what's missing? I'm kind of confused about that as well.
What's missing is the fact that we don't know that he precisely died from that. We know that he received damage. We knew they would receive injury, but there is nobody that the people presented to say, yes, this injury caused him to completely decompensate to the point where he no longer had any brain activity. We don't know what type of brain activity he had. We don't know what his injuries were. We don't know how long they could have been. We don't know if he could have came out of it or not. Now, I'm assuming, and we all can assume that, yes, he might have, but an assumption is not enough. It's not legally sufficient.
You're saying, you're conceding that he was hit with the wooden baluster.
Oh, yes.
Because of the DNA in the hair.
I will concede that, yes.
But what you're saying is, we don't know whether that blow was the blow that caused the fractured skull. Maybe he fell from there, hit his head on the ground. Maybe that caused the fracture. Maybe he wasn't fractured. Maybe he got home and he fell down the stairs and that caused a fracture. You're saying, we just don't know. And absent some kind of medical proof that ties it together, that the proof is lacking, and that proof is got to be beyond a reasonable doubt, and that's in the prosecutor's box of things they have to accomplish.
Yes, Your Honor, that's precisely what I'm saying, and that could have been accomplished with 2 or 3 questions.
Why was the medical examiner's testimony insufficient?
Because he was already dead, and she couldn't testify to what actually what was wrong with him as a result of the injuries. When she was asked, what was his cognitive functioning? What was his condition as a result of being hit and the result of these injuries? She said, that's hard for me to precisely say. She could only testify to the fact that, yes, he had blunt force trauma as a result of the autopsy. But anything before that, she couldn't testify to, and because he was already deceased. Now, again, what's missing is somebody from ECMC saying, yes, I treated him. Yes, he had these injuries. Yes, it was from being hit atop the head with a board or a baluster, like Judge Bannister said, but we don't have that. And it's my contention that it's not sufficient enough. And if we, go ahead.
She testified that the injury, the blunt force trauma injury, wasn't consistent with a fall.
She testified to that, but she would also testify that she wasn't sure what damage was he incurred as a result of that. She can testify that he died because of that, but technically he didn't die of that either. He died from being removed from the ventilator. So what I'm saying is there's a lot of confusion as to what his cause of death was and what exactly the injuries he suffered and how they led to being put on the ventilator. That confusion is borne out in a jury note where the jury asked if they could have the murder instruction and the causation instruction read again. It was confusing. It was confusing even for me to follow as to, well, how did he actually die here? I mean, yes, again, we can say, well, he probably died from getting hit upside the head, but probably is not enough. It's got to be beyond a reasonable doubt. Probably guilty just doesn't get us there. Unless there's any questions at that point, I'll move on to my second point. And that is the fact that Mr. Gianbaluca's confession should have been suppressed. It's a totality of circumstances analysis. One procedural defect in this is that the court's decision didn't really put forth any findings of facts as to why it shouldn't have been suppressed.
You know, the court had a video of the questioning when he actually gave up his rights.
He did, Your Honor. But we don't know what the court was thinking as to why he didn't suppress. I mean, we don't know what its reasoning was. So for me to come in here and say, well, it granted suppression or denied suppression because of this, I can't. So what I can do is tell you what's on the record and what I can see from the record. So, I mean, from the record, we can tell that there was testimony that Mr. Gianbaluca had psychotic disorder, he had cognitive disorganization, and a massive drug dependency. This affected the way he understood Miranda. There was an expert witness that testified on behalf of the defense as to whether or not he did understand Miranda substantively. And when he was asked what his understanding was in his own words, he said that, well, in court, a judge can force me to say that I did it. Add to that the fact that this person, Mr. Gianbaluca, he, for 24 to 36 hours prior to being put into custody and questioned, he did heroin, he did cocaine, he did alcohol, Suboxone, Wellbutrin. I don't know if I said alcohol, but I'll say it again. So, I mean, he was basically on a bender for 24 to 36 hours. They picked him off right off the heels of this bender. Given the lack of sleep, given the amount of drugs he ingested, given his already pre-existing injuries that were testified to by the expert, you needed a little something more than just, hey, do you understand Miranda? Yes. Do you wish to waive Miranda? Yeah. The officer that questioned him, I mean, you know, he could have done a little bit more to ascertain whether or not Mr. Gianbaluca actually understood Miranda.
But it is a great aid to us and the court that actually was recorded, and a court or us can make a decision based on what we saw, whether he was addled by all of those things that, you know, you mentioned.
Your Honor, and if you look at it, what you see is not great. The guy throughout most of the interview forgets where he was at any given point in time in the last 5 days. You can see that he mumbles a barely audible yes if he understands Miranda, and a barely audible yeah if he wishes to waive. So that is all out there, and you can tell. I mean, the guy is not, he's not all there. You know,
We'll take a look at that.
okay. Thank you, Your Honors. I appreciate it.
Thank you,
Good luck.
counsel.
Good morning. May it please the court, April Orlowski for the people. I strongly disagree that causation wasn't proved. The defendant admitted hitting the victim on the head or on the back of the head with the baluster. The baluster contained black and gray hairs and bodily fluid. The defendant's DNA was on the baluster, and the medical examiner did testify that the cause of death was blunt impact trauma, and that the wooden piece of deck or railing could have caused those injuries. So we believe that the causation was most definitely proven, and the jury.
The remoteness, you know, that it happened, you know, the actual physical contact happened in the parking lot and the death occurred at his apartment.
The sufficient cause of death is something that doesn't need to be immediate. A mere lapse of time will not necessarily serve to break the chain of causation. And here, the defendant didn't challenge the proof of causation with any sort of medical expert or contest the fact that the defendant died 2 days after the actual injury. None of that was even contested by the defendant at trial. The fact that the defendant was taken, or I'm sorry, that the victim was taken off of life support 2 days after, I mean, he never regained consciousness. He never regained any ability to live independently off of life support, gives creed to the fact that the injury he suffered caused his death, although not immediately. And the jury didn't specifically ask for any re-instruction on causation. So they weren't confused by the topic enough to ask the judge for a re-instruction on the issue of causation. With respect to the suppression issue hearing, That's not been preserved for review. But if the court wishes to hear it, the defendant, when he was being interrogated, made no indication that he was unable to do anything but validly waive his Miranda rights. If he was under custodial interrogation, because here he's not brought in under handcuff. He's placed in a room. He's not placed under arrest. He's given access to bathrooms, food, water, cigarettes. The officers don't at any time raise their voices with him, show a gun, place them under arrest. So it's reasonable for a reasonable person not to believe in that situation that he's under custodial interrogation. If the court believes he's under custodial interrogation, he was read his Miranda rights, and he was given a waiver card, which he signed. He didn't ask any questions. He didn't express any confusion. He suffered no infirmities. He rode his bicycle to the gas station where the detectives picked him up.
Right after the event.
Yes, well, it wasn't immediately, but they're relatively close in time. On the way to the police station, he spoke with the detectives about football and discussed his career in semi-pro football with them. He was alert and coherent when he entered the interrogation room. He provided the spelling of his name, last and first. He spoke about his wife and showed his wedding ring to demonstrate he was married. He answered in the affirmative to understanding and waiving his Miranda rights. And with respect to his inability to understand the Miranda warning, defendant's own expert testified defendant scored near the top of performance on the scale of tests, measuring his understanding of the Miranda warning. Defendant had a perfect score on the comprehension of Miranda rights test, and these were given by defendant's expert to defendant. He scored a 10 out of 12 points on the Miranda rights recognition and comprehension of Miranda vocabulary test, and scored a 28 out of 30 points on the function of rights interrogation. So unless the court has any further questions for me, we will rest on our brief. Thank you.
Next case number 244, Elstein versus Davidson Fink.
It's over the term.
What's that? Oh, excuse me. Case number 245, Home State Asset Management versus US Bank. Morning, Mr. Miller. Can you hear us?
I can, Your Honor. Good morning.
Okay, good. And we can hear you. Why don't you proceed?
Thank you. So this is an appeal of a decision, excuse me, denying a motion to dismiss three causes of action. We contend that longstanding black letter law was not followed in each of the three causes of action. Don't lie as a matter of law. The first cause of action was was for breach of a settlement agreement, and that settlement agreement was between the respondent, who was a borrower under the loan, and defendant U.S. Bank, who's not a party to this appeal. The defendant U.S. Bank had foreclosed on the loan against the respondent and entered a settlement agreement with the respondent, which is starts on page 20 of the record.
With respect to the agreement, I didn't see a lot of commentary in the brief about the role of KeyBank, who was signed on behalf of the trust. Vice President of KeyBank signs. Looks like KeyBank's address is listed as on the agreement, and the plaintiff attached to the complaint a letter from your client, I think Exhibit D, that talked about how your client stepped in the shoes of KeyBank within weeks after this settlement agreement. So why shouldn't we view essentially KeyBank's role in the agreement same now as your client, that your client essentially accepted whatever KeyBank did?
Your Honor, my client's role was pleaded by the plaintiff respondent, and it's clear they were the servicer. This was a CMBS loan. The Arbor was the servicer on the loan. They were pleaded to be the agent, and this settlement agreement was between the lender on the loan, who was US Bank, and the respondent. Arbor and KeyBank were not parties to the settlement agreement. They were just agents and a servicer for the lender. The
All right,
lender settled their dispute, which was the foreclosure action. Neither KeyBank or Arbor was a party to that foreclosure action, and it was
right.
settled.
No, I understand, but I mean, KeyBank, you would agree KeyBank signed on behalf of US Bank, right? Signed the
Correct.
agreement. It's there.
Correct. Yeah.
Plain as
Yeah.
day.
Yeah.
And you're not disputing what was written in that letter attached as Exhibit D, that the servicer, that's defendant Arbor, replaced KeyBank as special servicer on March 10th, 2022, when the loan was transferred. That's what it says in Exhibit D.
Yeah, there's no dispute about that, Your Honor. But the first cause of action in the complaint is for breach of a settlement agreement that is a contract that neither KeyBank or Arbor signed on its own behalf.
Right.
And neither of them was a party to the loan, and neither of them was a party to the foreclosure action, and the settlement agreement resolved the dispute between those parties. This case,
Here's the concern, and again, it's not quite sure if this is exactly what the judge was focused on below, but it certainly jumped out to me. When you look at that paragraph 8, which you rely on in terms of the costs that then had to come up. It looks to me as though paragraph 8 puts some responsibilities on the servicer, on KeyBank, because it talks about that the borrower shall be responsible for any reasonable performing loan fees. I'm referring to page 23 of the record. So that there's this sense of that the borrower agrees to be responsible for the reasonable performing loan fees. KeyBank is the one that's going to be setting those reasonable performing loan fees. KeyBank's going to be the one doing the work. That's clear from the agreement as well. So the question is, does it create a duty on behalf of KeyBank to be reasonable in essentially servicing the loan? And if that's the case, does that fall to Arbor?
So, Your Honor, let me say a few things about that. So those facts aren't in dispute. That a servicer and a special servicer, they're the agent on behalf of the lender who is collecting fees. This case is about fees that the plaintiff respondent claims are charged in violation of the settlement agreement. That's what they sued for. They didn't sue for violation of the letter. They didn't sue to try to claim that an agent of a party to the loan did something wrong and how they could articulate what they did wrong. The plaintiff has complete relief here against the part, if it could win, against US Bank, who was the party to the settlement agreement, if in fact US Bank charged the fees improperly. And the fees were collected by them improperly. And if they win, they will get complete relief. But Arbor wasn't a party to that settlement agreement. They didn't receive those fees. They didn't give the original loan. They didn't sign the settlement agreement, and they didn't foreclose on the loan that resulted in the settlement agreement. So even though they are the agent and they're servicing the loan, they weren't a party to the agreement that's being sued on here. And so
one thing, should the court have been concerned with Arbor's answer, where not Arbor's answer, I apologize, Arbor didn't answer, just moved. US Bank's answer, which is in the record 143, where US Bank generally denied the plaintiff's characterization of the trust as the lender. So now US Bank is saying, well, we're not the lender. So do we have finger pointing now going both ways, where US Bank is suggesting that KeyBank, or now Arbor, was really the party in interest?
Your Honor, I don't think that's a fact that is probative of this dispute, because the plaintiff is alleging who the parties to the settlement agreement are. They're suing under that settlement agreement, and the settlement agreement's a part of the record. The court can see who signed that settlement agreement. The court can see who gave the loan to the borrower respondent. The court can see who resolved that loan with the borrower respondent, and it can see that none of those parties were Arbor or KeyBank, because they were just an agent, a servicer on behalf of the lender. There's no other claims here besides that breach of the settlement agreement, or other claims that arise out of the settlement agreement. For example, the breach of the covenant of good faith and fair dealing arises out of the contract, the settlement agreement, and Arbor's not a party to that. So they they can't be liable for that as a matter of law. And similarly to the unjust enrichment claim, which is the second cause of action, that's a claim that a party that the law gives to a party when there is no contract. That's a quasi-contractual remedy. Here, the plaintiff is alleging there's a contract. They're suing on that contract, which is the settlement agreement. They're claiming the fees that were charged to it and that they paid were improper because they violated specific terms of the settlement agreement. That is what the pleadings are. And based on
No,
those pleadings,
I appreciate the pleadings, but if you're correct that there is no, they're not a party to the contract, that your client's not a party to the contract, which is your primary claim here, then why wouldn't the unjust enrichment claim lie? Right in
because
the alternative and say, all right, well, if you're not, you're still the one, your client's still the one that collected those fees and they were improper. And so now you've been unjustly enriched by the collection of those fees.
Because, Your Honor, there is a contract that covers and addresses specifically whether those fees were properly charged or not. And when there is a contract that directly addresses and covers whether fees are charged, a quasi-contractual remedy, whether it's against the parties to the contract or not, doesn't lie, because that quasi-contractual remedy only lies when there is no contract that specifically addresses whether those fees are covered. And Your Honors, if you look at the record on page 14, paragraph 18, and also the paragraphs dealing with the unjust enrichment claim, the plaintiff responded here specifically alleges that the fees were charged improperly because and that they violated the settlement agreement. It's the plaintiff respondent which is making those allegations, and which must be believed to be true because this is the motion to dismiss.
So if your client was a third party beneficiary under the settlement agreement, not a party, but a third party beneficiary, because you're going to be getting some fees at the end of the day here. If that was the case, your claim is that can't be sued for breach of the contract, can't be sued for unjust enrichment, even if the fees end up being improper.
Well, they didn't sue for that, Your Honor. There is no claim for those claims, and I would say that you're right, because they were the agent for the party to the contract, and it's well settled law. The agents can't violate the contract because they're not a party to it. They're just doing it on behalf of the party and servicing the underlying loan on behalf of the party. They cannot be liable for breach of the party's contracts, and there is no other claim that's been pleaded here or articulated against Arbor other than breach of the settlement agreement, breach of a complied covenant of good faith and dealing, which arises out of the settlement agreement, and unjust enrichment, as if there were no settlement agreement and some party received fees as if there was no settlement agreement.
Just the last question I have regarding the breach of duty of good faith and fair dealing, only because I don't think you're going to have an opportunity to respond to your opponent. There was a claim in the brief from your opponent that the separate agreement, the servicing agreement, could be the basis, that they could be a third party beneficiary of the servicing agreement, I think between your client and Fannie Mae or your client and US Bank. Would that require a separate cause of action altogether? To say, well, there's a breach of that, or a breach of good faith and fair dealing to the third party beneficiary under a different contract. Could that be pled under this complaint as it's broadly construed? Would you require a separate cause of action?
I think, Your Honor, the law is clear that it would have to be a separate cause of action, and understandably so, because a breach of implied covenant of faith and fair dealing arises out of a particular contract, of course. That contract that you're referencing, Your Honor, is not the subject of this complaint. If it became the subject of the complaint, one defense might be a breach of implied covenant of fair dealing doesn't lie, because whatever the plaintiff is alleging was breached is a specific term in the agreement. And if there is a specific term in the agreement, a breach of the covenant of good faith and fair dealing does not lie. So understandably, there would have to be a separate pleading addressing that contract, addressing that good faith and fair dealing claim before the court could rule on that respectfully.
Counsel, you should begin to wrap up.
Well, that's all I had, Your Honor, unless there's any other questions that the court has.
No other questions. Thank you, counsel.
Thank you, Your Honor.
Morning, may it please the court. Jordan Pavlis on behalf of the respondent, home state. And I have to say it's an honor to be here today. Justice Smith, I appeared many times before you, and I always knew when you were the presiding justice when my argument was over. That was a relief sometimes. I think Justice Nowak made pretty much every point I was going to make. We're on a pre-answer motion to dismiss here. And that's very important because we can make allegations in a complaint, but until we actually are able to engage in the discovery process, we don't know exactly what happened. We can allege, Justice Nowak pointed to the servicing agreement, right? We didn't know that existed until there was a motion to dismiss and they filed it in their supplemental papers. Could there be a cause of action that arises from the servicing agreement? There could be. We could be deemed a third-party beneficiary of that. But that is subject to possibly amending the complaint at a later point once we discover those facts. I mean, here we've got a breach of contract, unjust enrichment, pled in the alternative as a quasi-contract cause of action, and breach of good faith and fair dealing. If you look at the facts here, Arbor was the one that was acting and interacting with Home State at every stage. And essentially what they're saying on this appeal is it doesn't matter what we did, we're not liable for anything. And you can't hold us liable for anything, even though their actions are what precipitated this litigation. It was Arbor who insisted on extracting the monthly workout fees. It was Arbor who insisted on extracting the lump sum workout fees on the assumption transaction. It was Arbor that insisted on charging the additional attorney's fees on the assumption transaction. It was Arbor that we allege essentially engaged in the functional equivalent of privity by acting in the shoes and the stead of US Bank at every single stage, which, by the way, is a fact-intensive analysis that requires discovery. It was Arbor who acted at every single stage here. And it was also Arbor who we allege retained these workout fees. So that meets the definition of unjust enrichment precisely. They didn't have a right to collect the fees, and they kept the fees, and they were unjustly enriched. Now, we're entitled to plead those causes of action in the alternative. And on a pre-answer motion to dismiss, I think Judge Lamondola sized it up right. He essentially said, well, I have to take their allegations as true. They have to be liberally construed. So at this procedural juncture, I'm going to deny your motion. However, you might have another shot after discovery. It's essentially what the decision said. But we don't disagree with that. If after discovery, and we get a look at all their documents and we take testimony and depositions, if that establishes that Arbor wasn't acting in the functional equivalent of privity, that they didn't retain the fees, they can file their motion at that point. But
it did seem from your pleadings that, the biggest, one of the bigger issues that you had was that Arbor essentially took on the authority to deny the assumption of the loan at the time of the sale. That was really the crux of it, but you don't have a claim here for interference with contract or anything like that.
no, I think, it really comes down to a breach of contract cause of action, which applies in our view to Arbor because they were always acting in the shoes and the stead of US Bank. And it brings me to another important point, which is the assumption, the AAL letter, the assumption approval letter. Arbor's the one that drafted that letter. Arbor's the one that signed the letter and entered into that AAL with Home State. That's the best evidence you've got, that we've got at this point, without any discovery taking place, that Arbor acted in the shoes and in the stead of US Bank in every way.
But the claim essentially goes back to the settlement agreement, because if the withholding fees, attorney's fees, everything that they're demanding in that assumption letter, if those are correct, there's no problem with the assumption letter. The question is, are those correct? And those came from essentially the settlement agreement.
That's exactly right, Justice Nowak. I mean, I think it really comes down to, the court below will have the opportunity to just look at the language of that agreement and give us a yes or no. Because it's really just a contractual interpretation below on whether they had the right to extract these fees. The issue today is who's liable for that. And we believe it could be Arbor. I'm not saying it is, But we've alleged that it could be, and we're entitled to proceed with discovery, and they shouldn't be dismissed for the action.
Any further, counsel?
No, thank you, Your Honor.
Thank you. Case 246 in the matter of Anthone versus Carlo. Justice Bannister is recused from this case. Mr. Roach, can you hear us?
Yes, I can, Your Honor.
We can hear you loud and clear. Very good. Please proceed.
Thank you. May it please the court. David Roach, representing the petitioner appellant Karen Anthone. Your Honors, this appeal involves efforts to collect a judgment granted by Judge Bannister 16 and a half years ago. And normally, a sale of premises and satisfaction of a judgment under CPLR 5236 doesn't require judicial intervention. But in this particular case, the petition was brought because the property in question, 426 Hunt Road in Jamestown, New York, was owned half by the respondent, George Carlo, and half by an entity, the George Carlo Family Trust. When the commission...
Counselor, can I interrupt you just there for a minute?
Certainly.
In terms of the title, the court in its decision indicated that the property was owned, or the sole owner was the trust. You agree here with the respondent that it's a 50-50 ownership?
Yes, Your Honor. The court below was in error. George Carlo, the judgment debtor, never transferred his tenancy and common interest to the trust, but his brother Gerard did in 2016. Now, when we brought the petition, we had to bring it because we couldn't simply ask the sheriff. Normally, you'd provide a transcript of judgment, a description of the property, and identify any other lien holders. Well, the sheriff would not have known whether the trust was subject to the lien of the judgment. Prior to bringing the petition, George Carlo, in a sworn statement, had denied ever settling any trust or being the beneficiary of any trust. Subsequently, after the petition was commenced, discovery revealed, when we saw the trust for the first time, that George Carlo, in fact, was the settlor, was the sole beneficiary. It was a revocable trust, and the trust property included the other tenancy and common interest.
So, let me, if I could, this is a creator-controlled trust. There's probably no dispute about that. What exactly were you asking? You were asking for an order from the court directing the sheriff to sell the property. I understand that.
Yes.
But were you asking the court to also declare that this creator-controlled trust was no impediment to the sale?
Absolutely, Your Honor. Our argument was based on EPTL 7-3.1, which renders such trusts void against creditor claims, a longstanding common law tradition codified not only at 7-3.1, but also 10-10.6 of the EPTL. Now, the judge denied our motion because she said we failed to plead a self-settled trust. But as the court can see from the very record, paragraphs 12 and 13 of our petition, record 31, we pled just that upon information and belief, because at the time of the petition, we only had the sworn answer to our information subpoena from George Carlo that he had not settled any trust or was not the beneficiary of any trust.
Now, this is my last question on this, though. Does it make a difference? Is it still a self-settled trust, or is it a self-settled trust with respect to this real estate if his brother transferred the property to the trust?
Very good question, Your Honor. Yes, it is, because the trust terms explicitly allow third-party transfers into the trust for the benefit of George Carlo.
Your position is all of the corpus, the entire trust corpus is part of the self-settled trust, and then therefore as a creditor is entitled to attack or reach into the trust in all respects.
Yes, Your Honor, it is, because quite frankly, his brother could have simply transferred his tenancy and common interest directly to George Carlo, and then the two tenancy and common interests would have merged, and there would have been no trust involvement at all. But with the trust involvement, can George Carlo shelter these assets in the trust? And we're just concerned about an order to sell the premises. Can he shelter those from his creditors? And clearly the case law and the statutory law says he cannot, that the transfer is voided as against creditors. I believe it was pled. The parties knew what the issue was. The judgment been trying to collect it for years. And the question of fraudulent conveyance was no longer a part of this case, because initially there was a dismissal of Gerard Carlo's position in the case is named as a party because the fraudulent conveyance was only pled because we didn't know what the trust had to say. Also, we anticipated there might be a homestead exemption claim, which would only further delay the collection of the proceeds after a forced sale. And with respect to that, discovery had produced, we believe, is sufficient documentary evidence. One, a statement by the respondent, Lori Carlo, the trustee of the trust, that she said on social media in May of 2021 that the family relocated from Florida to North Carolina in 2019. And then a month earlier, the respondent, the judgment debtor, had submitted a life insurance policy application to Prudential, saying that his residence was North Carolina and his business address was actually the address in Jamestown, New York. So more importantly, the case law we cite, Vanderbilt, Schenck, commentaries, Scott on trusts, and Professor Rohan indicate that in this kind of situation with a self-settled trust, it is unnecessary, or with the self-settled trust, you don't need to prove fraudulent conveyance in order for the trust assets to be void as against creditor claims. There's an argument made by the respondents that this is simply estate planning. That is not what the case they cite, County of Warren, stands for. And if simply calling this an estate plan would eliminate 7-3.1, 7-3.1 would be a worthless statute in the situation. So we ask for a reversal. We believe prima facie establishment of the ownership by the trust, a self-settled trust, and also the inapplicability of the homestead exemption, so that we can go forth and put the sheriff in a position to finally make a sale that would be in satisfaction of this very old judgment.
Thank you, counsel.
Thank you.
Morning. Brian Whitford, respondents. Congratulations, gentlemen. Look, in this case, it really comes down to pleadings. As the trial court noted, the pleadings matter here. So there's no question that this petition, this verified petition, has a single claim. Creation of the Carlo Family Trust and contributions of remainder interests are fraudulent conveyance within the New York debtor creditor law. It's paragraph 14 of the verified petition on page 31 of the record. That's the claim.
Well, but really, this is a special proceeding to direct the sheriff to sell this property.
It is.
But for the fact that the title is split between your client and a trust, that's the only impediment to the court ordering this sale.
And so according to the pleading, what this verified petition, what they say they're going to show is, we're going to show there's a fraudulent conveyance, and that puts the property in the sole interest of the debtor, George Carlo. That was the intent of this verified petition. The petitioner put the burden on herself by pleading it the way she did. And so she now has to prove a claim to obtain the relief she wants. And the problem on summary judgment is she didn't prove her claim. So the court looked and said, well, what claim have you alleged? The only claim you've alleged is fraudulent conveyance. There was no conveyance by George Carlo. So we're left with a piece of property owned tenants in common by George Carlo and the trust.
Now, there's an allegation in paragraph 12 that George Carlo is the settler of the Carlo family trust. That's not enough?
It's not enough, no. And by the way, George Carlo is the settler. Mr. Roach said he's the sole beneficiary. That's not true. His wife and his children are beneficiaries of the trust. So we have issues that weren't properly pleaded. They brought, at the end of the day, it's the wrong claim. What they need to bring is a partition action to deal with this tenants in common. And then we can deal with the homestead exemption too, which the trial court never got to. And there are a number of issues of fact, as we state in our brief, as to what George Carlo's residency is. The evidence is his license shows the Jamestown property. He filed his taxes through the Jamestown property. But we never get to that point because the court shouldn't have gotten to that point. The court just stopped and said, well, you haven't proven the items you need to prove to obtain summary judgment. There are legal issues, there are issues of fact, and they just didn't carry their burden. And so, but it all comes back to the same thing. What they pleaded can't be proven. They brought the wrong action. So if you want to do it appropriately, and I understand what they're trying to do, they need to deal with the tenant in common issue and they need to deal with the homestead issue, neither of which were before the trial court.
We'll take a look at that, counsel. Thank you.
Thank you.
Thank you.
Case 248 is submitted. Case 249 and 250 is Cirino versus Cirino.
Morning, may it please the court and counsel. Henry Jones, on behalf of the plaintiff, appellant respondent Barbara Sherino. May I just add my congratulations to Justice Smith. Been retired for a while now, but here I am. We get right to the heart of this case. Really, certainly one of the two most important issues, I think, is wasteful dissipation. And I'd just like to point out a couple.
I'm having a bit of trouble with this theory. I mean, yes, there was a failed hardware store, but just because you go ahead and try something doesn't mean that you're wastefully dissipating assets. And then you bring up the redevelopment of that old school building. And again, so things didn't quite work out, but that doesn't mean necessarily that you are wastefully dissipating assets. And lastly, the merit trade. People have been losing money in the stock trading forever. So I'm having trouble with that concept.
Well, let's start with the Ameritrading first. He's financing that trading, Your Honor, with unpaid tax money. He hasn't paid he didn't pay taxes for the entire time he's trading. From 2016 to 2000.
Responsible for those taxes.
That is correct.
Right. He's
But
responsible for them. She is not responsible for them at the end of the day.
Well, there was an $88,000 credit to Mr. Sherino, which we claim was unsupported by the record. There was no benefit. Usually it's marital debt. And if the parties enjoy a benefit from the non-payment of taxes, as I point out in my brief, then it's correct to apportion it. There was no benefit here. The unpaid taxes went right into a merit trade. So he's playing with money he doesn't have, is what I would say regarding the Ameritrade. Now, the old school and the hardware store. Again,
let's stay with the Ameritrade just for a second.
Sure.
You know, and tell me if I'm wrong in thinking about it in this way. If he had, say, taken a large sum of money and placed it in one stock, and that stock went down, And he didn't really properly research it, and it was kind of like walking up to the gambling table in the casino and putting it all on black, right? On that roulette table. I might be getting to where you want us to be in terms of recklessness, right? And maybe even bad faith, but that's not what happened here. What happened here was a series of transactions over a period of time, right? Some were good, some were not good. And isn't that more in line with a typical trader, a person that, a lot of people do this, that are just trading stocks and not doing it recklessly or not in bad faith, and maybe taking more risk on than they should, and depending on where the risk falls in a person's psyche, right?
Well, once again, I think the recklessness comes from playing with money he doesn't have. But to your example, I would say that after maybe, the first couple of years, the first year was fine. He made, I think, $3,000 the first year. After that, things sort of go downhill. And you would think after a year or two that, boy, maybe I'm not cut out for this. I really need to think about this, or to get some advice. Year after year after year, instead of paying his taxes, he takes the unpaid money from taxes and dumps it into Ameritrade and loses it. I think that's a perfect example of recklessness and perfect example of the kind of wasteful dissipation.
And that's where we have to get. We have to get to kind of that standard recklessness, right?
That is correct. And I think Mr. Sciarrino is stuck with that, as long as he says that it's dicta and all that. He cites Grunfeld in his post-trial submission, says bad faith or recklessness. It's not bad faith and recklessness, it's bad faith or recklessness. So recklessness is a standard, and I think Mr. Sciarrino's traditionally.
We'll take a look at that. You were about to get onto the other items and pass the Ameritrade. So I'll let you go.
That's right.
Yeah.
Well, with the old school, right around he doesn't pay his taxes in 2004, can't afford to refinance in his own name. He admits that. It says his business wasn't up and running at the time. Excuse me. And he can't afford to refinance $236,000, because he's taking out more than 10 times that. It's obvious that he's in over his head from the start. Can't afford to refinance his mortgage. To $2.5 million of personally guaranteed funds drops in his lap. That to me, it shows that he was in over his head from the start. The hardware store, once again, he says, okay, well, his testimony right on the record says, so you were trying to make a go of it, right? Asked on cross-examination. He says, well, no, I wasn't trying to make a go of it. I had these two guys. So it's like, tell these two guys, go out and make this hardware store viable. Go out and run. That's not the case law. It's pretty clear. Mismanagement, it's the Bruskewitz, pardon the pronunciation, where there was mismanagement of rental property. Here, there's no management. He just says, go out and run my hardware store. You would think, assuming the losses are linear here, after the first year, it's like $75,000 is out the door. Somebody's asleep at the switch. And so I contend that that's reckless as well. And as far as the whole Mahoney-Buntsman issue, Mr. Sciarrino says that Mahoney-Buntsman controls. I couldn't disagree more. It's the truly excessive nature of the expenses has to be determined really at the time the expenses were made, not at any other time. Now, the only other defense that Mr. Sciarrino, and this is related to the hardware store, was that he basically refers to Ms. Sciarrino as his business partner through all that, through that project. And that's just not the case. Doesn't deny that they had disagreements about that they thought about the whole thing. And so I just think those defenses are without merit. Barrister Lane, if you look at the court's property distribution, it was just totally skewed in favor of Mr. Sciarrino, and the record shows how well suited Ms. Sciarrino is to the business to her, and she loses the house, she loses the business. I think under the circumstances of this case, that would be inequitable in the extreme. Point three, as the court's aware, the lake house, that issue has been rendered moot. But still the issue of the credits survived. And I just did mention the $88,000 tax credit, but we believe that's improper. And let me just mention briefly maintenance. First of all, in doing family law for a while, I've never seen an appellate case where the child support or maintenance, where an obligation was reduced in the favor of somebody that didn't disclose their income to the court. Mr. Chirino became delinquent in his 2022 taxes rather than disclose his 2022 and 2023 income to the court. So I think Mr. Chirino contends that failure not only warrants the dismissal of his cross appeal, but the increase in his obligation as set forth in my brief.
And before you sit down, I was going to ask you about the cross appeal. If you could, give us your 2 cents before you can't do that any longer.
Yeah, well, that was where the cross appeal relates to the duration of maintenance, and the amount of maintenance. As far as the duration of maintenance, as I say in point 4A of my reply brief, unpreserved, judicially estopped. And then as far as the amount goes, when a litigant fails to disclose income, the case law is pretty clear that it deprives the court of the ability to fairly adjudicate the issue, basically barring that person from receiving affirmative relief. So that's.
One more question before you sit down. They ask for some relief on the life insurance obligation, and what's your position with regard to that?
We agree that the life insurance should be adjusted to reflect Mr. Chirino's support obligation. That's the purpose of life insurance. So we certainly agree that life insurance obligation should be adjusted to the amount of
his obligation.
That's true. Exactly. Yes. And
Thank you, counsel.
Okay. Thank you, counsel. Thank you, Your Honor.
May it please the court, Brian Jones for Raymond Chirino. This is an appeal that should not be here. This is a trial that should not have happened. The trial court judge was practically pleading with the parties to settle the case. At the time of the trial, I'm remembering correctly, their total marital estate was valued at around $400,000. And I believe they had $294,000 in debt and racked up nearly $300,000 on behalf of the wife's attorney at trial, which a number was astronomical for the Fourth Department. We do rely on Mahoney-Bunzman. The marriage is an economic partnership. You can't bow out at the bottom of the ninth because it's getting rocky and you change your mind and things are suddenly, headed south. As the court has already pointed out, it's an investment. It's a gamble. The wife clearly enjoyed the vacations, the jewelry, the benefits, and can't then turn around and say, I'm out. It's all of his fault. I had no part in this. When you can see in the record her involvement. She did the marketing. She did the PR. She was the designer.
With respect to the school property rehab, she did the marketing. She did things is that what you're referring to?
Yes, that she was involved. She may not have been as involved with the financial aspect.
She wasn't involved with the Ameritrade account, apparently, because I think she was surprised to learn about that, right?
That is my understanding.
Yeah.
Yes. But it's also where... I'm sorry, I lost my train of thought.
I'll do that.
Do you think that the court balanced all of those issues when it came up with its decision, the debts versus the assets and the liabilities going forward? Or is there, an unbalance that we have to address here?
I actually feel overall, the court did balance it well. And the husband, former husband, has been responsible all along. He prioritized things in the way that mattered to him. The wife may not have agreed. He borrowed money instead of declaring bankruptcy, as she was looking for him to do. He honored the promises he had made to friends and family who loaned them the money to try to build what they were looking for retirement. I do feel it is appropriate for him to, or the marital residence to be sold as the judgment lays out, and continues or split it as the court initially did.
Anything further?
No.
Thank you, Counsel.
Thank you.
Case 251, Yakovitz versus Upstate Tower Company LLC. Judge Del Conte is recused.
Good morning, Your Honors. Robert Knorr for the plaintiff appellant Derkovitz. Before I begin my argument, I do want to take a moment. I wanted to point out to the court that I noticed in preparing for argument today that there was a misstatement in my brief, particularly as regard to a case, Murphy versus Town of Oyster Bay. It's a proper case, it's properly cited, but it is referenced as a 4th Department case, and it's actually a 2nd Department case. I just wanted to point that out to the court.
That on both, it doesn't.
Justice Smith, I assumed that you could go back and forth on that, but I felt compelled to point that out to the court.
Appreciate that, counsel. Thank you.
This case really comes down to how to interpret this contract. And there's a lot of first-year contract law involved here with regard to ambiguity and contradictum, et cetera. But I think the context of how this contract came about is very important. The Derkovitzes had a piece of property. They were approached unsolicited by a representative of Upstate. They were told that if they leased a little piece of their property to Upstate, they would cost them nothing. They would not have to pay utilities or taxes, and that they would get a net amount every month. Now, how do we know that? There was an affidavit in the record from Mr. Derkovitz. Mr. Carpenter came to me. He said this. It is not denied. There's no denial that that conversation took place. And I would submit it's not hearsay because it's being submitted not for the truth so much as both a statement against interest as well as a declaration that Mr. Derkovitz heard. That context is important because then he's presented with this contract that was fully created by Upstate. And this contract very carefully defines certain terms. Real property is defined, capitalized and defined. Communications facility, capitalized and defined as Upstate's personal property. Communications facility is very clearly defined as Upstate's personal property. They make that point over and over, saying that it's personal property. It can be taken away from the real property. It is our property. Yes.
Personal property taxes are not defined.
Personal property taxes are neither capitalized nor defined.
Now, there's an argument made in the briefs that the meaning of that was, since there are no personal property taxes in New York, is that, well, in the future, maybe in the future, if New York decides to go the way of Georgia or South Carolina, and we have personal property taxes, that's what they're responsible for. My question is, if that is the reading, does the contract require additional clarifying language? Does it require language that says in the future, potential future personal property taxes, something like that? Are there words left out?
I would say there are, Your Honor, on 2 points. That, number one, being the fact that if the state later introduces personal property taxes, we'll pay them. That's one thing. But the other thing is that the personal property taxes are not either capitalized or defined, and they come right after the statement that says the communications facility is our personal property. My client, not a lawyer, didn't have any reason to understand what happens in Georgia. And in fact, Upstate's aware of this contradiction because in the record, the counsel for Upstate put in other claims, not whole contracts, but just a little piece that talks about property taxes. Clearly, there's something there. And there's another case, which is cited in our brief. It was presented in the 2nd Department, Tundo, in which that court found exactly what we're saying on the basis of surplusage. If it doesn't mean that you're going to pay the taxes on your personal property, what does it mean in the context of this contract? And I know that case isn't precedential, but it certainly points out that a reasoned judge came to the same conclusion we did. So clearly that term is not clear. And it certainly wasn't clear to Mr. and Mrs. Dirkovitz. So in going forward, this contract was presented to Mr. Dirkovitz. He read it. It had the terms that he thought were supposed to be in it. He understood personal property taxes to mean they are going to pay any increase. And so the tower gets built and the assessment goes up. So the Dirkovitz hire an attorney to try to challenge the assessment. And the town agrees this is appropriate to have a separate tax identification number, not a separate parcel. I want to make that very clear. There is not a separate parcel here. And our brief makes that clear, showing that the town clearly is saying this is the value of the personal property cell tower versus the land. And property, the property taxes, is defined in their contract by the deed in a meets and bounds description. Not improvements on property. We all know improvements attached become, but that's not what they're saying. They have a meets and bounds description. They've paid all the taxes on that meets and bounds description. The Dirkovitz don't feel that they should be obligated to pay the taxes on the personal property. So they had the town clearly identify, clearly separate, so there's no question. And we really firmly believe that that's the proper interpretation of this contract. And I'm happy to answer any questions.
No questions, counsel. Thank you.
Thank you.
Morning, Your Honors. Justice Smith, I'll just pass along the same congratulations and appreciation. Your Honor, I'll start with where counsel started because he wants to talk about the construct of the agreement. There is nothing within this record to suggest that there wasn't a full and fair opportunity to negotiate the lease. There was nothing in the record to suggest that there was any untoward pressure put on him or that he couldn't have counsel. So the notion that Mr. Dirkowitz read it but didn't really understand it, to us, Your Honor, the appellants in this case are asking you to violate 4 or 5 well-established principles, both as a matter of law and contract interpretation. You are charged first with knowing what's in a contract and understanding it. You don't get to suggest after the fact that you didn't understand it. Here, in addition, the record shows that Mr. Dirkowitz, by his own acknowledgement, did not focus on any part of the contract except the rent terms. Those are the terms that matter to him, the base rent and the escalation rent. So principle number 2 is you don't get to complain or object to an understanding of a contract that you admittedly did not review in full or appreciate with respect to other terms except the terms you focused on.
So your reading of the contract is that the Dirkovitzes owe these taxes, not your client.
Correct. And that brings me to my third point as a matter of law. There are no personal property taxes in New York, as Justice Nowak said. There are, however, real estate taxes, and counsels acknowledge that real estate taxes, and there can be no lack of clarity under paragraph 9 in the agreement. It says real estate-based taxes are to be paid by the appellant.
I don't know that that's the clause that they're pointing to that is in dispute. It's the 2 sentences later in the same paragraph. We'll pay all personal property taxes on the communications facility. And it doesn't end with in the future. It ends with on time, which actually implies the opposite of in the future. It implies that there's something now because we're gonna have to pay it on time, coming up soon, kind of thing.
Sure.
So why isn't that misleading? Why isn't that at least ambiguous?
Not at all, Your Honor, for 2 reasons. My comment was that the entirety of the provision is titled taxes or taxation. Secondly, the first sentence makes clear that real estate taxes are to be paid by the appellant. Under the T-Mobile DeBellis case, it's very clear, the Court of Appeals has said, when it's appropriate to tax communications facilities, that is a matter of real property law. That is a tax under the RPTL. There are different conditions that have to apply as to whether cellular communication equipment can be taxed or not, but the case is such that it is a real estate tax. And there can be no dispute here that under the contract, real estate taxes are the function of what the appellant pays. The last point that I might make, Your Honor, is there is long established precedent that you can't simply change the terms after the fact. There is no ambiguity, respectfully, with respect to the real estate taxes to be borne by the appellant, and the current state of New York law being those assessments are a real estate tax. These terms are negotiated. Rent would have changed. Escalation clauses would have changed. You cannot grant respectfully the relief that the plaintiff seeks without undoing the contract in its entirety and prejudicing my client, creating a new bargain.
We'll take a look at that, Mr. Devendorf. Thank you.
Your Honor, sorry. Thank you.
Case 251.1 in the matter of Anderson Enrique v.
Good afternoon, Your Honors. Sylvia Woodmansee for the appellant. Before I get started, I wanted to thank this court for granting my client's motion to have this appeal heard during this earlier term and squeezing us into today's calendar. This appeal is about whether my client has established the special findings of fact that would enable him to petition U.S. Citizenship and Immigration Services, USCIS, for special immigrant juvenile status. Based on an independent factual review of the record on appeal, this court should reverse the surrogate court's denial of my client's motion for special findings of fact and issue an order granting his motion and declaring that he has established each requested finding of fact in accordance with 8 U.S.C. section 1101. The practical implications of ruling in my client's favor on appeal are that he will then be eligible to petition U.S. Citizenship and Immigration Services for special immigrant juvenile status before he turns 21 on July 2nd.
Now, Counselor, you need to file your application before that date, is that correct?
That's correct, yes. He must submit his I-136-360 petition to USCIS before he turns 21. This, of course, does not...
Is that how far ahead?
It just needs to be postmarked by that date. And of course, this does not guarantee USCIS will in fact grant him special immigrant juvenile status. The surrogate court's decision denying my client's motion only mentioned one of the requested special findings of fact, whether reunification of my client with one or both of his parents is not viable due to neglect, abuse, abandonment, or some similar basis under New York state law. I will thus focus on that fact during this argument, but I'm prepared to respond to questions on any of the others. And the record here unequivocally demonstrates that reunification of my client with his parents is not viable due to neglect because his parents failed to do anything to protect him after his life was threatened by gang members other than suggesting he leave the area. This forced my client to commence a dangerous weeks-long journey to the United States by himself, where he was at substantial risk of serious physical injury or death. By suggesting he leave the area, my client's parents knowingly set him on that perilous journey. And we can infer from the record that my client's parents were aware of the dangers because his older brother had already immigrated to the United States, but my client's parents let him go anyway. And the Appellate Division has found reunification not viable when addressing denials of motions for special findings of fact in the special immigrant juvenile status context, where parents did not provide adequate support after their children were threatened by gang members. I'd point you in particular to a matter of Nelson AGL, Maria YGS, that's a Second Department case from 2018, where the court found reunification not viable due to neglect and abandonment, where the child testified that after they were approached by gang members in El Salvador on their walk to school, the parents did not make any transportation arrangements or do anything to deter gang recruitment activities, although aware of such activities. And the child further testified his parents strongly encouraged him to leave home, but did not provide alternative living arrangements and did not support him after his arrival in New York. My client is similarly situated and has declared that after his life was threatened by gang members,
His parents did not take him to speak with anyone about what he had experienced and did not offer him any solutions for how he could stay safe other than suggesting he leave the area. Additionally, every other factor that my client through counsel asked the surrogate court to consider in determining whether reunification with his parents is not viable due to neglect supports ruling in his favor on this appeal. There's evidence in the record suggesting that he needed medical treatment as a young child for physical injuries and psychological care after his life was threatened by gang members, but his parents did not provide medical nor psychiatric care. His parents also did not ensure he stayed in school in Guatemala, instead switching him to a difficult and potentially dangerous full-time manual labor job on his father's farm at the age of 15 when he was only in 7th grade. From 15 to 17, he worked on the farm and did not return to school until he came to the United States, and he's currently in high school. The Appellate Division has also found parental neglect where parents required children to work instead of attending school and did not ensure they received a proper education. I'd point you there to matter of Gurwinder S., that's the 2nd Department in 2017, finding reunification not viable due to neglect and stating neglect includes requiring the child to begin working at age 15 instead of attending school on a regular basis. The Appellate Division has also found reunification not viable where parents have ceased providing financially for their child, which is also the case here. My client's parents have not provided for him financially at all since he arrived in New York. I'd point you there to Sarah D. versus Licinia D., where the 1st Department in 2022 found reunification not viable within the meaning of the Family Court Act, where the child's testimony showed the parent did not provide for medical emotional needs while in the Ivory Coast and had not contributed to her financial support since she arrived in the US, which is the case for my client as well.
Is it my understanding that none of these facts that you've put in your brief and talked about today, none of them were contradicted at trial?
Correct. The special immigrant juvenile status cases are unopposed, and so the court had to rely on the affidavits that are in the record and the testimony and determine whether it was credible. There were no negative credibility determinations made during the hearing. And as you pointed out, because this is an unopposed case, there is no evidence or testimony to the contrary.
The letter decision from the court didn't indicate why there was any issue with the grounds that you raised.
Correct, it did not. In its very short letter decision, the court made 2 statements. It first said, well, it made a number of statements, but it said that it could not determine that my client is a special immigrant as that term is defined. That, of course, is not a determination for the surrogate court to make. That is USCIS's determination. It also stated there is no credible testimony presented of abuse, abandonment, or neglect, or that reunification with one or both of his parents is not viable, but it did not explain its reasoning. And although credibility determinations of the lower court are afforded deference on appeal, the case law in this area makes clear that this court is free to make its own credibility determinations and overturn the determination of the hearing court when the credibility determination is not supported by the record.
And that's what you'd like us to do?
Correct.
Very good. I think we have your argument, counsel.
I'm sorry, could you repeat that?
I think we have your argument. Anything further?
I did want to briefly address, since I still have a few minutes, I believe the last requested special finding of fact, which is whether it's in my client's best interest to be returned to Guatemala. That was not addressed in the surrogate court's decision, but it is integral to my client's motion and important to consider here. And the record demonstrates that in Guatemala, my client would be at risk of gang violence and his parents would still have no solution to keep him safe. He would also be unable to stay in high school and receive a high school diploma. I'd point you here in particular to matter of Victor Arcio Canales, which I won't recite in detail, but the court there found it was not in the child's best interest to be returned to Honduras, where there were similar threats of gang violence and similar testimony from the child that he felt scared all the time and could no longer live a normal life. If there are no further questions, that is That is all I have.
No further questions, counsel. Thank you.
All right, thank you.